he and Bangalore. When they set their exams, it was very well, then they filed it. Couple of letter 3, 2010, volume 10, SCC page 707. That is Vijay Srivan. It's the state of Madhya Pardesh. It's from blood to para 15 of the order.
Yes.
My lord has come to para 15.
Yes.
Delhi. Has come to para 15.
Yes.
Delhi with my lord's information.
Yes.
Para 14 of September. However, the main argument was the evidence against entertaining WPC and so is on the ground that the PIL in service matter is not maintenance. This court is of the opinion that there is considerable merit in that contention. It is common ground that dispute in this case is an over-selection and appointment which is a service matter. In Duryodhan Sahu, Dr. versus Jitendra Kumar Mishra, that is 2010-10 SCP 707, a 3-judge bench of this decision held that the PIL is not maintainable in service matters. This court, speaking through Srinivasan J, explained the purpose of administrative governance created under Article 323A in the background of extraordinary jurisdiction of the High Court under Article 227-226. This court held in public interest litigants at the instance of strangers are allowed to be entertained by the administrative tribunal. The very object of speedy disposal of service matters would get defeated. Same reasoning applies here as service matters as public interest litigation has been filed when the entire dispute relates to selection and appointment, just like my case. Paragraph 16. In B. Srinivasan Reddy, that is 2006 volume 11, SCC 731, and this court held that service matter only the non-appointees can assess the legality of the appointment procedure. That is the end of the matter, Lord, in most of the cases. Paragraph 17. This view was very strongly expressed by this court in Datta Nathunji Pawade versus State of Maharashtra, that is 2005 volume 1 SCC 590, by pointing that despite the decision in Duryodhan Sahu, PILs in service matters continue unabated. This court opined that the High Court should throw out such petitions in view of the decision in Duryodhan Sahu. The same principles have been reiterated in Ashok Kumar Pandey in a recent decision of this court delivered on peace trust. Thus, in Panchlal, it has been held that except in the case of co-warrant of PAL in a service matter is not implemented. Now, paragraph 20. The next point urged by the appellants that they have never been included in the two petitions, even as the orders passed by the High Court had a direct effect on their livelihood, also goes to the root of the matter as it violates the principle of order. They are also what? I put my nose, Lord, only in two petitions. Look, please hear me. In one case, in another case, I'm intervener. Now, para 21. This court in Prabodh Verma versus State of UP held the High Court ought not to decide the writ petition under Article 2 to 6 of the Constitution without the person who would be vitally affected by its judgment before it as the respondents. They have never bothered to make any of us as parties. No. So many of them selected. Similarly, this court in Rama, all these judgments are recorded. And para 23 there is another important judgment. Para 23D Ramachini versus State of Andhra Pradesh, where selection of certain teachers was challenged without impeding them. This court held selection process has commenced long back, as early as in 1998, and it had been completed. The persons selected were appointed pursuant to the selections made and had been performing their duties. However, the selected candidates have not been implicated as parties to the proceedings, either in the individual capacity or in the representative capacity. In the view of the matter, the High Court ought not to have examined any of the questions raised before it in the proceedings initiated for it. To that extent, the Supreme Court has gone. The writ petitions filed by the clients concerned ought to have been dismissed, which are more or less in the nature of a public interest litigation. So, Lord, this is the judgment of J. Srivastava. I have requested my Lord's leader also to show me another judgment that is called Lord Saroj Kumari, 2017, volume 9, SCC page 478. Because Lord,
On the same point.
no, it is on the point that we were very happy appearing in the exam, my Lord. आराम से एग्जाम है लॉर्ड दी रूल्स वर पब्लिश्ड लॉर्ड वे बैक इन 6 months लेकिन मैंने my lord everyone is given the chronology to my lord I've also given the chronology in my return उसमें मैंने तारीखें बताई हैं हाँ जी हाँ ये रूल है 28/6/2018 को एक रूल हुआ मध्य प्रदेश का रूल 1/7/2018 हुआ everyone is very happy 6/1/2020 primary school teacher eligibility test advertised and everyone participated peacefully on 5.
Some recent view has come or not?
No, not I have been distinguished. I don't think it is because
When can a person who participated can still challenge or not challenge? To what extent he can challenge?
when you have grievance before commencement of the part. Yeah, because when I was appealing for the leader to it used to come after the selection process. Now, Lord, the most important thing is that Lord, all these questions regarding whether I am representing those B.ed candidates who have been selected, appointed. They are working. Now, Lord, as far as K.C. Nandan and Rohit Kumar, the cases are concerned, it goes because of not this judgment which has not Srivastava. Because, and as far as the other petition is concerned, even in that law, they have not, my Lord, bothered to any of the selected candidates. Everyone knew that the selection and the appointment had been done. Lord, pray that appointments of the interveners was issued on 33/2023. उसके बाद सब पिटीशन पेश की Why not make any of them the parties? No, I will not make them parties, but they are. Not my brother.
Petitions, right?
I want to reiterate that. That is it. That Lord, there are many. There may be many cases in which B.ed candidates might have lost in high courts. I want to make that. Many candidates, not B.ed candidates, might have lost in the High Court. Then they went to Supreme Court. Supreme Court would say that no, your appointment is subject to the final decision of the sensitivity. So, in a petition filed by them, if their appointments are subject to the final decision, that is what the Supreme Court judgment says. Everywhere they say their appointment would be subject to final outcome of the case, which might have been instituted by them. Yeah. We have not instituted any case. State of Madhya Pardesh was very happy to entertain B.ed candidates. We participated in the selection process. Exact interpretation of the Supreme.
That Mr. Gildial has submitted.
Yes. I adopt his argument and the argument will be
May I respond to these arguments, Growth, for a minute?
You want to say something?
Yes, I just want to respond to two things. One,
You are appearing
the fact that we did.
All these arguments are unstated. All these arguments, all others, Lord, except Vipin Kumar Dwivedi, are not worth considering alone.
मेरा क्वेश्चन कितना है ऑनरेबल सुप्रीम कोर्ट ने साफ कहा है कि दो सेट के बारे में पहला सेट होगा जो किसी भी प्रोटेक्शन को लेकर के वो अपॉइंट नहीं हुए वो है बहुत सारे ऐसे स्टेट जिन्होंने बीएड को अपने नोटिफिकेशन में लिया ही नहीं तो उन्होंने साफ अपॉइंटीज हुए उनको निकाल दिया जाए उत्तर प्रदेश में 11/10/2023 के पहले एक भी बीएड अपॉइंटीज जो है हाई कोर्ट नहीं आया किसी भी कोर्ट में गया ना ही किसी कोर्ट ने उसको अपने ग्रांट करके के द्वारा उसको अपॉइंट किया तो हमारा कंसर्न यहाँ पर कि हमें देसी नंदा सेना किसी चीज क्योंकि जो है हमें तो माननीय सुप्रीम कोर्ट ने साफ तौर पर सेट बंद में रखा मध्य प्रदेश सेट बंद कर रखा
Manoj, can I just respond to what my friends had said? Number one, as far as not making them parties, when we filed our petitions, no appointments had taken place. So there was no question of making anybody parties when we made when we filed our petitions. Second, all those petitions had interim orders which made it clear that it was subject to the outcome. So we presume that the state, if they are going to make appointments, are going to be informing the people they are appointing that it is subject to the outcome of court proceedings, to which the state is very much a party at that point of time. Point number three, repeatedly they have drawn attention to these words at the top of page 8 of the Supreme Court order. Let me just read that again so your lordships have the entire context of it, because they have for some reason decided to amputate that sentence. Let me just read fully the entire paragraph from bottom of page 7. As it appears that a large number of candidates with B.ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities. So this would necessarily have to include B.ed as an eligibility criteria for them to be appointed. We do not think it be equitable to effect the removal. Therefore, this is not the Rajasthan scenario at all. We accordingly hold that the judgment delivered by this bench on 11th August shall have prospective operation. But prospective operation, from here the exception starts, where they will not have the protection. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law, to the effect that their appointment would be subject to final outcome of the case, which might have been instituted. These words by them is what they're emphasizing, saying that it could only be if it's filed by the B.ed candidates. By them, I would interpret to mean by whoever the petitioners are in that particular case, because the rest of the sentence makes sense, which might have been instituted by them and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.ed was stipulated to be valid qualification. B.ed was stipulated to be a valid qualification in Madhya Pardesh, not in Rajasthan. No B.ed candidate would go to the court when B.ed qualification is given in his advertisement. He would only go when it's not given. Therefore, it is very clear that this petition, this order provides that B.ed candidates who had qualifications provided in their advertisement, who had participated and then were made subject to a order of the court, will not have the protection, provided they were appointed prior to 11th August 23. If you are appointed after 11th August 23, there is no protection. That I think even Mr. Patwala will concede. That is the nature of the prospective order.
When were these petitioners appointed?
These petitioners, now as far as the interviews are concerned,
30th March 23 and 10th August 23.
now 10th August 23 is not an appointment. Your Lordship may check that. There's not one single appointment which took place on 10th August. It's a notification listing those who would be appointed. So the appointments themselves took place after 11th August 23.
So they are all before the judgment.
Correct. They have all been
Some
appointed.
of them are before, some are after.
They have all been appointed before.
Your Lordship may ask for the list from the state with the names of appointments. Lord's, our unequivocal submission is that every single appointment took place after Your Lordship's interim order. The minute it took place after Your Lordship's interim order, they lose the protection. The interim order is 7th July 22. It takes note of the Rajasthan High Court judgment.
With Vipin Kumar, there was an interim.
Is my lord on the 16th January 23. 16th January 23, much before the appointment on 30th.
July 22, 7th July 22 in my case, Your Lordships took note of the Rajasthan High Court judgment and specifically said in view of the above,
You give us that 2-3 days, just this week. Please give us.
we'll give you a note, my lords, with all that.
Date of appointment. This is all. The date of appointment.
Appointment are
My
only
lord,
2 days.
I had pointed
The
page number
appointment
16.
orders are 30th
Page number
March
16.
2020 and 10th
16.
August 2023.
Mr. Patwalia, to make it easy for the court, it is the
And-
state government evidence.
And the appointment orders are clear. They are not subject to anything. They are categoric orders of appointment. And
So
they are
court's orders are categorical. Court's orders make it subject to.
Yes.
Government can't decide to do what it wants on its own.
My lords, just to assist my lords, please see page number 16. This is a part of affidavit of the state of MP filed before Supreme Court. It starts at page 13 of the compilations and page number. There's also one thing out there. While according to them, 11,583 out of which 2,784 being made on that notification on 10th of August 2023, which they state, they clearly say 284 have been made after 11. And they write that they had only issued a notification and that the appointments had to be sent later on, which is mentioned there.
Alright, so these the first 2 cases, they are diploma holders. What about the remaining? All of them are diploma holders.
My lord, there was no need for the B.ed to approach the court in Madhya Pradesh because under the existing thing, B.ed were eligible. So the challenge to that was made by the diploma holders. And my lords, may I just in 2 lines respond to what has been argued? I would respectfully submit that I heard that argument being made on the other side, that whether in person or in representative capacity. Now, in representative capacity, impleadment was filed before Supreme Court on 11th October 2022, where Supreme Court reiterated the same stay of being subject to the orders issued in the petitions in the case. Now, they were aware even at that time, all the B.ed, and subsequently the B.ed have filed their infringements. So, my lords, that argument and showing all the judgments of not being made a party, etc., is actually holds no water for the reason that they have been before my lords, and the courts have held that in any manner a representative capacity is sufficient in these matters.
All right, we are resolving the case and asking the state to file a tabular illustration. After extensive arguments, the case stands reserved for passing final orders. Next, further, the council state is directed to file a tabular illustration mentioning date of appointment of whose appointment?
B.ed.
Appointment of the B.ed candidates.
B.ed.
So date of appointment letter being issued, that would be important. Date of appointment letter being issued, not the notification.
We'll reserve it and wait for yours. That we have.
Grateful, very grateful, my lord, for the hearing. Very grateful.
Locus. On what point? What is the point?
It raised an important public issue and involved the interpretation of Article 156 of the Constitution of India. And advice we do not think that we can deny locus to the petitioner or raising that the article of that.
What is Article 156? What has that got to do with service matter?
Article 21. Okay. Education.
No, you are talking about Article 156. Say,
Article 21.
So this is children centric.
Yes. Not to do with the teachers at all.
That issue open now.
वो आप दे दीजिए फोटोकॉपी दे दीजिए फोटोकॉपी यस हो गया यस
Grateful, my lord.
Obliged, my lords. We are very grateful for very patient.
Very grateful.
Great.
$29 CRC. Possibility of time not possible to learn this space for this on only Wednesday, Thursday in the month of July. Principal directions. Plans हो गया? कर दिया? और इसमें learned counsel for the petitioner informs that the order, final order dated by which this petitioner is disposed of, tax compliant.